My sincere apologies for not being available at the first call. In this writ petition, my lords, we're basically challenging a notification, my lords, of 2nd January 2024, by which the state did not consider me the petitioner for the post of primary teachers, relying upon an honorable Supreme Court's judgment. I am a diploma in elementary education laws, for short d.el.ed candidate, and I have completed my course in 18 months from under a Government of India scheme from National Institute of Open School. The requirement of state to apply for this job is that you should have a 24-month diploma. But under a Government of India scheme, I did
the state requires a 24-month diploma.
I'm sorry,
the state requires a 24-month diploma
under the NCTE guideline. As per the NCTE, because National Council for Teachers Education prescribes the guideline, and NCTE says 24 months is the period for which one should have done diploma in elementary education to apply for a post of a primary teacher.
And you have done it under
18 months approved by NCTE from NIOS, National Institute of Open School. Once this course was introduced, my lord, the NCTE said that both these courses are equivalent. So therefore, in 2019, in 2020, in 2021, all three recruitments that happened prior to the Supreme Court judgment, the state called similar applicants like me and included us in the recruitment process. Thereafter, for one state of Uttarakhand, one judgment came from the Honorable Supreme Court in November 28th November 23, by which multiple states felt that my diploma, my recognition has been nullified by the Honorable Supreme. So thereafter, within 10 days of that Supreme Court judgment, the state issued a notification saying that people like me are no more eligible. Multiple review petitions were filed before the Honorable Court.
For which post?
For post of a primary teacher in state-run schools. Primary teacher in state-run schools. The post will be assistant teacher. The name of the post will be assistant teacher. Assistant teacher in primary school. That is the job. So, my lord, after that, what happened? That one state did not include me. Some petitioners likely came before this honorable court in a batch of writ petitions saying that we are not covered with Javeed Singh. Therefore, please consider it. That is a different batch petition. Some of us, my lords, including from the state of Assam, went to the Honorable Supreme Court that, see, everyone is misunderstanding your order. Therefore, please clarify that our course is a valid course and we are eligible. After hearing all of us, my lords, including some of us from the state of Assam and the state which was a party before the Honorable Supreme Court, on 10th December 24, the Honorable Supreme Court clarifies that yes, your course is valid and it is at par with the 24 months. The Honorable Supreme Court clarified. State of Assam is the part. It not just clarifies that, I'll show the documents, I just wanted to give the brief. It not just clarifies, it also says that the clarification will be applicable from a backdate. Now, which is the backdate? The backdate is the judgment which they had passed, relying upon which the state came out with this notification. So 10th December 24, the Honorable Supreme Court clarifies with a backdate, with state of Assam being a party.
In which case has it clarified?
In Javeed Singh versus Union of India, my lord, the order, my lord, would find at page 46. The same judgment where they relied upon removing...
And where is the earlier judgment?
The earlier judgment is also Javeed Singh. The earlier judgment is not on record, my lord, by which they removed me, that is not on record. But by which it is clarified is on record because it is filed in the very same judgment. The very same SLP. Because that it was
a different case.
Same case. Same case. The judgment which was passed by the Honorable Supreme Court saying that the court...
What was the judgment passed in the earlier judgment? Let me see.
Javeed Singh versus Union of India.
Which date?
Javeed Singh was state of Uttarakhand, 28th November 23. 28th November 23.
23.
Yes. In that judgment, against that judgment, review petitions are filed. And that
judgment is not here.
That judgment is not here.
Why?
Well, we just wanted to place the
How it is?
November 23. In Civil Appeal 7873 of 23, it is a reportable judgment.
Civil Appeal
7873 of 2023, judgment dated 28th November 2023. And then my lord would kindly come to page 46 of the writ petition for a minute, page 46. Page 46. My lord would see on top, review petition civil number so-and-so on the top, my lord would see. In civil appeal number 7873 of 23. My lord, that page 46.
What is the review number?
The review petition number is 4961. 4961 is the review number.
The review
4961 of 2024.
Is it their number? It's not review petition number.
No, this is the only, because I had the opportunity of filing this review, Malad, I had only filed it. At this stage, Malad, because there was a delay, the review petition number never came. It was only at the ID stage. Unless the delay is condoned, therefore it will not come. And in the same page, if my lord would see in the same very page, fifth application, which is miscellaneous application die number 42144. Fifth application is where state of Assam is a part. The same page, page 46, fifth application number, MA die number 42144 of 24. That is where state of Assam is a party. And now the relevant part comes at page 47, my lord.
How thick is it? 47.
Yes, 47, para 3. May I read, my lord?
Yeah.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10th August 2017 and who have completed the diploma course of 18 months would be treated as a valid diploma holders for the purpose of applying in other institutions or for promotional revenue.
Who were in employment?
In employment, very, very important. All of us are in employment.
As on 10/8/2017.
That is the first condition.
So, are you in employment?
Yes,
10/8/17?
I am in employment. I have produced my proof in this writ petition. For each petitioner, I have produced.
No. So, why have you come if you are in employment?
Yes, the answer to that is this, Lord, that I was in employment in a private school when on 10th August 2017.
You are in a private school.
In a private school.
Private school doesn't count.
Well, Lord, the Honorable Supreme Court has examined this, whether I was in employment in a private or a government, at a later order, which I will just show.
So you were in a private school.
As on
When did you join a government school?
I have not joined, Maloj. I am applying for the
you're
first
not in a
time.
government.
I have never joined a government school. If I was, therefore, I am applying for the present post, which is of a government school. And this query, which fell from my lord, has been clarified by the Honorable Supreme Court in the subsequent orders, which I'll just show. So I was just reading that para 3, my lord. Valid diploma holder, first condition, in employment as on 10/8/17. Second condition, that should have completed the diploma course of 18 months. That is the second condition. Would be treated as valid diploma holders for the purpose of applying in other institution or for promotional revenue. And then para 4, my lord. Needless to state that the clarification will be effective from the date of pronouncement of the judgment under review. The judgment under review is, my lord, 28/11/23. The advertisement, which is the subject matter of the present writ petition, is 26th December 23, 1 month later. So this is a clarification the Honorable Supreme Court gave.
Yes, sir. What is this recognition order?
Because the recognition order is basically the course that I have done, which is the 18-month course, that was approved by the government and NCT. Because all of us who were in service, we didn't want to lose our job. Therefore, government made an amendment in the RTE Act saying that whoever is in service can be trained while being in service. And this course of 18 months, which I am doing, was recognized by the NCT by an order of September 2007. So this is the recognition order which is mentioned.
Please read para 2.
My lord, we have already clarified in the judgment under review that one-time scheme was provided solely to safeguard the interest of those teachers who were employed as on 10/8/17. We are therefore not inclined to entertain the present review petitions as well as miscellaneous applications.
So this is only to safeguard the interest of those teachers
Indeed, my lord.
who are already employed as on 10/8/17.
And all of us are employed, my lord. We have produced.
The issue is whether this order covers private schools
Yes,
as well.
that is
Government.
yes, that has been covered, my lord. If my lord would just have the next, because this is the order, the primary order for clarification. Then the Honorable Supreme Court implements this order. And that is something which will throw clarity on the fact that whether government, private is important or not important. Can I just show that? And that will clarify. Kindly come to the first order of implementation, which is at 118. The earlier order is passed by a different bench, Justice Gawai. This order is passed by a different bench, applying the order of the Honorable Supreme Court, but for a different state. And I had the opportunity to assist the Honorable Supreme Court in this matter at 118. My Lord would have 118.
Yes.
My Lord, this is an order passed in for the state of Bihar. My Lord would kindly come to para 3, which is at 119. And the date of this order is 2012, 10 days after the earlier order. Miss Manisha so-and-so appears for the NCT and so-and-so. Counsel appears for the NIOS. They both are supporting the applicants. Miss Karya also submits that the open so-and-so is recognized by the NCT. Then the relevant part is reproduced in para 4. Para 6 is important, my lord. In the interim, we deem it appropriate to allow the participation of the applicants in the counseling process being conducted by the Bihar Public Service Commission. The outcome of the counseling process, so far as the applicants are concerned, be kept confidential. This is made subject to further orders to be passed in this act. So therefore, my lord, in the state of Bihar's matter, this is implemented. And then,
not exactly. It is allowed. I mean, it's not implemented.
Well, this is one order.
It's subject to the outcome.
Yes. This is one order. I'm showing two more orders. Kindly have for the state of Uttarakhand, my lord, there's a detailed judgment passed, and that will clarify my lord's doubt on whether in-service would mean primary or secondary, because the order of the Honorable Supreme Court says in-service as on 10/8. And when the NCT recognition order came, that also said you have to be in service, whether in government, private, that is irrelevant. That is what the recognition order says. But this, my lord, would be clarified at page 400. Kindly have 400 for a minute. This is further clarified, my lord. My lords have page 400. I'm sorry.
Yes.
Lords would see this is a judgment passed to the state of Uttarakhand, my lord.
Yes.
My lord would kindly have the para 1, what is being considered by the Honorable Supreme Court. This is 1 month back. By way of this application, the applicants have approached this court for a direction on the respondent to permit the applicants who are holding the 18 months d.el.ed qualification from the NIOS under the open and distance learning mode to participate in the ongoing counseling process and to subsequently be appointed to the vacant post in the ongoing recruitment. This is the issue. Then my lord would kindly come to page 404. They are talking about the original judgment, my lord. Page 404, para 9 is important, my lord, after this. I will just take 2 minutes on this judgment, my lord, because it is slightly important. Page 404, para 9. Challenging the aforesaid judgment, this is the original judgment, and order passed by the High Court, a batch of appeals came to be filed before this court. The said appeals were decided in the case of Jaiveer Singh and others versus State of Uttarakhand, dated 20th November 23. In the said judgment, if one of us is a member, this court upheld the validity of the rule. In the aforesaid case itself, this court had clarified that the scheme was framed by the Government of India by the aforementioned recognition order was done in order to provide a one-time opportunity to such of the teachers who were already in employment as on 10th August 2017 to get a qualification of a diploma course as required under 23(2) of the Right to Education Act, which had been inserted by the 2017 Amendment Act with retrospective effect from 1st April 15. I will pause here for a second. The RTE Act does not differentiate government school, private school. It does not. It simply says that whoever is in employment has to get this qualification. Now kindly have with me further, my lord. Then, my lord, para 12 is important. It appeared, because the same confusion is my grievance in the present writ petition. It appears that there was some confusion in some of the states, and therefore review petitions, miscellaneous applications were filed. Kindly have para 14, my lords, then. This court clarified via para 3 and 4 of order dated 10th December 2024, titled as so and so as under. The two paragraphs which I read, my lords, are reproduced in page 406 and so. Then, my lord, may kindly have para 15. The grievance of the applicant herein is that though they are eligible as per original judgment of this court dated 28th December 2023 and the clarification dated 10th December 2024, in as much as the advertisement in the state of Uttarakhand is dated 29th May 2024, this is after the judgment was delivered on so and so. It is submitted that in reply given by the state government, it is stated that the selection process is almost complete and therefore the claim of the applicants cannot be considered. Just to distinguish on fact note, here the selection process is not even commenced. Only document verification is going on. There is no appointment. In state of Uttarakhand, 90% of the appointments were done. Then, my lord, would kindly come to para 20, which is at 407. In fact, para 19, which is the identical situation vis-a-vis state of Assam as compared to state of Uttarakhand. Kindly have para 19, page 407. This is the learned counsel appearing on behalf of the state. On the contrary, submits that while judgment dated 20th November 2023, this court had upheld the 2012 rules of the state of Uttarakhand, which provided that a diploma for 2 years or equivalent was necessary for being appointed as teacher. She further states that any interference at this stage would cause the complication in the selection process so and so. Now, please see 20, my lord. No doubt that this court has upheld the 2012 rules framed by the state government while judgment dated so and so. However, that is where I fit in, my lord. At the same time, this court had clarified that such of the teachers who were already in employment as on 10th August 17, again, there is no distinction that they are citing to.
I don't know. That is the issue we have to pick. Carry on.
Would be entitled to the benefit of one-time scheme provided by the government of India. This court held that such of the teachers who have completed the diploma course of 18 months would be treated as a valid diploma holders for the purpose of applying in other institution or for promotional revenue. Now, 21 is very, very important. Indisputably, the other institutions would also include the schools run by the state government. I would pause there for a minute. Look, if I am already placed in a state government school, where is the need for me to again reapply to any state government school? If, my lord, I am already working in a state government school, what was the need for me to reapply to a process, my lord, to say that now please consider me? Hence, they have said, my lord, that's indisputably other institutions, meaning where you are not working, would also include the schools run by the state government. So, when this argument was tendered, my lord, and the basis of review was that if I am working in a private school and I want to switch to a government school, then why wouldn't this course, in my humble submission, be equivalent? And therefore, the Honorable Court answers the query that we had put, the state had put, that when you have to apply to other institutions would include the schools run by the state government.
So you mean to say everything was decided for private schools? Is it?
What I mean to say, my lord, that
was the entire issue with regard to private schools, and then at the end the Supreme Court had said that the other schools, it also includes government schools.
What was decided earlier, my lord, was not covering the fact that they were in service or not. In fact, in the original judgment also I can show, they have always protected in service. Now what they are saying is that whoever was not in service, we don't care about them. But whoever was in service on 10th August 17, we are protecting them. And that is what flows from the main judgment also. But somehow, my lords, most of the states did not misunderstood in my respectful submission that judgment, and hence this clarification is coming. And then kindly see further also.
You see, what I don't understand is,
My lord.
do your petitioners have a problem with private schools?
My lords, the answer to that is this, my lord. On 10th August 2017, my lords, after that COVID came, most of these schools have shut down. So therefore, my lords, I have completed, this was the course had to be completed by 31st March 2019. I have completed the course in 2019. Thereafter, I have lost job, my lord. I don't have a job. The relevance of this 10th August 17 is flowing from the recognition order. The recognition order says that you have to be in service as on 10th August 2017. Now the Honorable Supreme Court says so. So therefore, when we argued this review petition, my lord, and I can say with that responsibility, my lord, that our argument was that if the schools have shut or these government schools give us a better prospect, then why should I not be considered eligible to apply for these government schools? And therefore, in answer to that, all this is being clarified. And this is not the one, this is not just one instance. This is one of the judgments of Uttarakhand. 5 days later, there is a judgment of West Bengal also on the same issue by the Honorable Supreme Court, where they say that wherever you are in service is irrelevant. You have to be in service.
Where is that?
We are just getting a copy of it. It's just 2 days back. Lord, I've asked my colleague to get a copy. 2 days back, they pronounced it. Again, we had the opportunity to assist the Honorable Supreme Court. But kindly have the next, my lord. Just one more paragraph in this, and I'll be done with this, my lord. Para 22. We find that the case of the present applicants would be covered by this court's clarification dated 10th December 24. Now, my lord, these applicants were represented by me. I know for a fact that all of them were private school people. The present petitioner are also in service in private school, my lord. So there is no distinction in facts in both these cases. I have, in fact, if my lord would want to see their documents, I can show their documents of these people who were before the Honorable Supreme Court. All of them were in private school as on 10th August 17, but this was never the issue that where were you in service. And then, my lord, kindly see 23. We therefore direct the state government to consider the claim of the applicants in accordance with the clarification dated 10 December 24. And if the applicants are found to be eligible, to appoint them in accordance with law. The same shall be done within a period of 3 months from today. We further clarify that while doing so, the state government would not reopen the selection already conducted. Here, there is no selection that has been done. And then, my lord would see on the next page, the writ petition. In fact, because this was a transfer, my lord, at 410, my lord would see. The writ petition is, transfer petition is also allowed. And the writ petition, which my lord would see at 411, the prayer, my lord would kindly have at, at page 409. 409 record that the writ petition also stands allowed. Now, this writ petition, which are mentioned for the state of Uttarakhand, are identical to the present writ petition. I say it with responsibility because I filed both. And this is one of the examples where Honorable Supreme Court is implementing, my lord. I have placed on record other High Court judgments also. That how the other High Courts have also implemented this is also of relevance because everyone, my lord, except State of Assam, seems to be understanding the position set out very correctly in my humble submission. And my lord would kindly have just 2 such examples, which my lord would kindly see at page 398. 398 is how Calcutta High Court has dealt with the same issue and granted a relief in favor of the petitioner, saying that yes, you are covered, therefore you are eligible, therefore you are appointed. Has gone to that extent. 2 such examples I have put in. If my lord could kindly have 398 for a minute. 398. And there it is dealt with the primary school only. In fact, that query that fell, my lord, that is categorically dealt with. Of course, it is not binding, my lord, but it's only for reference to assist, my lord. That's how the different High Courts have taken a view. Kindly have 398 for a minute. This is the Calcutta High Court, my lord. My lord would kindly see the petitioner on 10th married.
Yeah.
The petitioner on 10th February was appointed as a teacher in Loretto's St. Mary's Girls Primary School, a Christian minority school, not a government school. Subsequently being selected in the recruitment process, he had joined St. So-and-so Free Primary School. As her such appointment was approved by the so-and-so, the respondent so-and-so. The said approval, however, has been withdrawn by the impugned order dated so and so on the ground that training qualification of the petitioner, that is 18 months d.el.ed course conducted by the NIOS, is not a valid training qualification for the appointment of teacher in a primary school as held by so and so. Then, my lord, the next paragraph. The Honorable Supreme Court on a review application by order dated so and so has clarified the following, which we just read, my lord. And kindly come to the next page. The petitioner, since is in service and had, well, very, very important at 399. The petitioner, since is in service, no bifurcation of whether government or private, had completed the said training course in the year 2017-19, is eligible to get the benefit of the said clarificatory order of the Honorable Supreme Court. The order impugned, therefore, is not sustainable and is accordingly set aside. The present challenge in the writ petition is a similar order. What is being challenged before the Calcutta High Court? All the benefits accrued to the petitioner upon setting aside of the order impugned be released. WPA so and so is allowed. So therefore, this is how Calcutta High Court has dealt with the matter. This is the rest of all. And these are the 4 judgments where Supreme Court has implemented. 3 I have shown, my lord. I am showing the West Bengal one, which is 3 days prior, my lord. It starts, my lord, at page 16. In this page 16, it starts, my lord. These are just the 4 judgments that have been implemented by the Honorable Supreme Court. Page 16, it starts. So I can just give a backup. My lord, have that compilation that I have tendered. Page 16, it starts the reportable judgment.
Yeah.
If I could just give the background before reading the judgment. In this matter, my lord, what happened that prior to clarification, the Calcutta High Court held against us, saying that we are not eligible. So therefore, the aggrieved party, as in us, people similarly placed like us from the state of West Bengal, went to the Honorable Supreme Court saying that Calcutta High Court, Honorable Calcutta High Court has held that we are not eligible, relying upon your judgment. Now, this judgment, which I'll just read, sets aside the Calcutta High Court judgment, saying that no, they are at par, they are completely eligible to participate in the recruitment process. So therefore, this SLP was allowed, setting aside the judgment of the Honorable Calcutta High Court, which said that we are not eligible. The Honorable Supreme Court said, no, you are absolutely wrong. Both of these groups, 24 years vis-a-vis 18 months, is at par with each other. They use the word at par. And that is what is recorded in this judgment. So therefore, this 3-4 paragraph may be seen, my lord, in this judgment, which is of 4th April 2025. My lord would kindly have page 21. 4 para 4.11.
Yeah.
My lord would see that on 24 July 24, Division Bench of the High Court, Calcutta High Court, by placing reliance on the judgment of this court in case so-and-so, dismissed the intra-court appeal. So therefore, what the Honorable Supreme Court is recording that yes, the High Court said that they are not equal, and then the reasoning comes. Kindly have 4.14. It is pertinent to note that on 10th December 24, the bench of this court, of which one of us was a party, passed an order in the case of Vishwanath and others versus state of Uttarakhand, which I just read, my lord, in a batch of matters containing review petitions and miscellaneous applications, essentially seeking a review of the judgment in so-and-so. Again, my lord, on 21st February 2025, another coordinate bench of this court, taking note of the fact that judgment of this court in the case of Jaiveer Singh, so also the subsequent clarification by order of this court in so-and-so was rendered by so-and-so, directed the registry to place. They're just giving the facts, my lord. And then my lord would kindly have page para 6, which is 22. This gives the relevance of whether it could be any school, which my lord put a query to me, or it has to be only government school, private school, etc. So therefore, my lord may kindly have para 6. The so-and-so learned senior counsel and parent of the appellant submitted that the central government through MHRD by way of letter dated 31st August 2017 had extended the period for training of such of the in-service untrained teachers in government aided, unaided private schools. Very, very important. 3 categories given, and we fall in that category is my submission. Government aided / unaided private schools on 31st to 31st March 2019. It is further submitted that NCT, which is the town authority for deciding the qualification, my lords, relax certain provisions of the NCT regulations, thereby reducing the course duration of the 2-year d.el.ed program to 18 months. So the NCT did it, not me, my lord. It is therefore submitted that any teacher who was in service as on 10th August 17 and who was undertaken the 18 months d.el.ed program through nios before 31st March is to be considered a valid diploma holder for the purpose of continuing in service, promotional avenues, or applying to other institutions. All three things covered. Then my lord would come to page. There's some facts of West Bengal are mentioned, my lord. That may be kindly ignored. My lords may kindly come to page 26, para 13. Page 26, para 13. May I read, my lord? It however so happens that on 3rd August 2017, the central government through MHRD apprises all the states and UTs that in terms of section 23 of the RT Act, the in-service untrained elementary teachers in the government aided, unaided private school are required to be trained. In order to give a statutory effect to the aforesaid letter, the Parliament carried out an amendment in the RT Act, therefore added a second proviso to subsection 2 of 23 of the Right to Education Act, and the same was notified on 10th August 2017. Therefore, this date is important, my lords. 10th August 2017 is the date of amendment. And hence, every court is lying upon this 10th August 2017. Then, my lord would kindly come to para 14. It is pertinent to note that the second proviso to subsection 2 of 23 of the RT Act provides that every teacher, very, very important, or in position, appointed or in position as on 31st March 2015, who does not possess minimum qualification, shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Act. Accordingly, the date of commencement of the Act so-and-so was fixed to be 1st April 2015. The in-service untrained elementary teachers had to require the minimum qualification by so-and-so. Thereafter, my lords, para 15, that how is this was reduced, my lords. It is done by NCT, not by statutory authority, my lords. Para 15 is important. This is the recognition order, which my lord was asking me about, my lord. So therefore, this is important, my lord. The NCT thereafter on 22nd September 2017 passed a recognition order. It is relevant to note that the NCT, only after considering the recommendation of an expert committee, sought to grant relaxation to certain provisions of the 2014 NCT regulations so as to ensure compliance with Section 23 of the RTE Act as it stood amended on 10th August 17. The NCT therefore reduced the duration of the d.el.ed through ODL system, which is me, my lord, recognized in so-and-so. The duration of the d.el.ed program was reduced to 18 months instead of 2 years by including subsuming the 6-month internship within the 18 months. This is very, very important because this was argued that why are they equivalent? It was not reduced, but only the internship was given short. The NCT also granted recognition approval to NIOs for conducting the 18-month d.el.ed program. And then my lord would kindly come to page the recognition order is also reproduced, my lord, which my lord would kindly have page 32. That also deals with 3 classes, my lord, private school, government school, etc. So 32, my lord, the recognition order starts. If my lord would have 32 for a minute. 32, my lord, the recognition order is reproduced. And then the relevant, my lord, is at 34 in bold. 34, para 43 in bold. It further clarifies that the NCT recognition order dated 22nd September 17 was only for those untrained in-service teachers in government aided or unaided private schools who were appointed on or before 10th August 17. The bold part in page 34. And then, my lord, would kindly come to page 35. page 35, para kindly have page 30, page at 43. NCT prescribes the minimal eligibility. All states have to follow it. They are the rightful authority under the RT Act. The NCT, after the Supreme Court judgment, has written to the state of Assam in January 25 that please implement and consider them equivalent. And that is also on record, my lord. My lord would kindly have page 413. 413, my lord. I'm sorry, I'm making my lords go through pages there and there, my lord. I apologize for that. My lord, this is slightly, it may not clear. Like, I'm sorry, it is not that clear, my lord. Page 413, if my lord would have. On the right side, the date is mentioned 27th January 25, topmost, and it is by National Council for Teachers Education. The subject is very, very important, my lord. I will just read it, my lord. To forward the order dated so and so.
Anyway, so what is to be done now? What is to be done now?
What is to be done? Look, if I can just.
You're only challenging the notice.
Yes, that is one part, my lord. And there is already a process going on. I have produced that the verification document list on record. For the same very advertisement, my lord, they are verifying the documents of the 24-month one.
The last date of submission of applications expired.
Expired, and I had applied.
You applied.
All of us have applied. All of us have applied. And if we have applied, my lord, there are two things, Lord, what I'm praying for. One, because it is at the stage of document verification, the notice is annexed. And it started like 2 days prior. In fact, last 31st March, it started. There are two things, my lord. One is that all of us, my lord, which is the petitioners, 40 of us, may be called for document verification. That is point number one that I'm pressing my lord for. Second, my lord, this notification, in my respectful submission, should have been withdrawn by now because there is an Honorable Supreme Court's order and State of Assam was a party. And then this NCT order, my lord, which is also issued to them, saying that please implement it, which is NCT is the rightful authority.
That is page
413.
413.
It is issued to them, my lord. The Chief Secretary has been served with a copy by the NCT. And the NCT supporting our stand is recorded in the Honorable Supreme Court. So therefore, my lord, my argument or my submission for my lord, kind consideration is twofold. This notification in terms of the Honorable Supreme Court clarification implementation is to be stayed, ultimately set aside. Secondly, my lord, 40 of us may be called for document verification, my lord, and be considered eligible in terms of the judgment passed by the Honorable Supreme Court and implemented by other state at par with others. And it is not as if I was never considered. I was considered in 2019 by the state of Assam. I was considered in 2021 by the state of Assam. Lying upon an Honorable Supreme Court judgment, they felt.
So basically, what you're trying to say is that the judgment passed earlier has basically been reviewed.
Indeed. In effect, it has been reviewed. In effect, it has been reviewed, my lord, and that is why they have implemented. In fact, whichever High Court followed the earlier judgment, they have now set it aside. Which I just said, one of the state of West Bengal, they simply followed the earlier judgment. And now the Honorable Supreme Court sets aside that judgment, saying that this is not what we meant.
So you took part in the advertisement A and B.
I took participate in A and B. In 26 December, the advertisement A and B, one is for class 1 to 5, the other is for class 6 to 8. And all 40 of us, my lords, have taken part. We have applied, my lord, because the verification process is ongoing. Therefore, my lord, we would want to participate in the verification process and also stay, my lord. This is very, very important because till this time my hurdle is stayed. They will come back and say that we don't consider you eligible. The question that I put to myself is, my lord, that once state of Assam has been a party throughout, what basis would they have, my lord? Specifically, my lord, even if they are not a party, judgment in rem, my lord, it's not a judgment in persona in my humble. So therefore, my lord, what remains, specifically when there is a clear-cut direct. And one last thing, my lord, in the other matter, which is the batch that is pending, my lord, there was a stay on the verification passed by coordinate bench of this court. They went in appeal, my lord, and that all those writ petitions were filed prior to the review. The state went in appeal, my lord. I must be fair to report. The state gave a concession there that we will consider the respondents, as in the petitioner, for verification, but did not make any statement regarding the eligibility. Today, that matter was again listed before a coordinate bench for those petitions which were filed prior to the clarification, where the state took a stand that those writ petitions are prior to the review, therefore nothing can be done there, and the eligibility is still in question. But the present writ petition, and therefore I think it has been listed separately, my lord, is not distinguishing ourselves from Jaiva. We say that we are getting benefit of that order. Please implement it for us. That is the short point. So therefore, technically, we may be different from what is happening there. We are
Anyway, let us hear the other side. Yes. Yes.
grateful, Manoj, deeply grateful.
Basically, I think they should be also be. They should also.
One confusion left.
Yes.
The Honorable Division Bench judgment regarding the physical verification of documents,
Ah.
selection where they want to participate.
Yes. Yes.
First of all, it is not there in the writ petition which is the exact advertisement of selection process they want to participate. Neither there is a statement that this is the particular advertisement, neither there is next to the writ petition anywhere. So we do not know which advertisement is talking about.
They have participated in.
We do not know whether, and there's not one sentence in the entire writ petition saying that yes, we have given our forms, we have participated, and we are being left. The prayer clause, if Lordship would see, and the Lordship will see. That is at page 42.
Yes.
Lordship, page 43, prayer number 4.
Yes.
Direct the respondents to include the petitioners in the ongoing verification process released by notification dated 18/3/25. Direct the respondents to include the petitioners in any recruitment process for assistant teachers so-and-so conducted in the state from 28/11/2023 in adherence to applicable directions. Now, in the
this white
petition, I do not find that they participated. What had happened is, when we gave the notification, we are not allowing the 18 months d.el.ed to participate, people rushed to the point. The learner single just rejected the prayer for interim protection, saying that you would not be allowed to participate. The Supreme Court in JVC said so and so. Only in the interim part was rejected. Notices were issued. Those petitioners went to the division bench. Division bench said, allow them to participate for the time being. Do not declare the results. It remained done. Writ petitions continue. We do not know whether these persons have
participated
or not, because there were two batches. One, before that notification, whoever could apply had applied with 18 months d.el.ed. After the notification, that part was being removed. So they approached the court. Now, again, those people also applied because they were within that particular time frame of the last date of application. And the order for allowing them to apply was also restricted to those.
Here we don't know if
we
they
don't
applied.
know. There is no statement that yes, we have applied. Number one. So this
what we can say
yes
is that if they have submitted,
Lordship will have the division bench order. Why we made this statement?
okay,
Division bench order, Lordship. Lordship would have paragraph. Then, my lord, the interim order is given. Now, Lordship would have paragraph 11. Mr. Saikia, so-and-so submitted that the state does not want to delay the matter pertaining to verification of the documents of the candidates who had applied pursuant to the said advertisement dated so-and-so for the posts of so-and-so. On being inquired, Mr. So-and-so also submitted that during the second phase of such physical documents verification, the authority concerned will also consider the applications submitted by the present respondents. Mr. Saikia submitted that the Directorate of Elementary Education during physical documentation shall verify the credentials now of all those applicants who have submitted their candidatures pursuant to the said advertisement dated 26/12, including candidates having 18 months dated. So this division bench judgment, in fact, will cover the case of the petitioners in case they have already applied. It will not cover them if
they don't apply.
If they did not apply. This is first one. Second one, matters which are taken up by a court bench, emphasis was made that it should be restricted only to petitioners and applicants before the court.
Naturally, no one wants competition.
Now, if 18 months is eligible, in my humble submission, it's in rem. Everybody will have to be considered. We cannot restrict it to persons. If 18 months is eligible, 18 months is eligible.
No, 18 months only for those who have been in service. and who have completed
Exactly,
it prior to
all
April
people,
19th.
all people, if it is made applicable for 18 months who had been in service on 10th of August 2017, any person who was there will have to be eligible.
Provided they have participated.
Can we only
Those. So it can be
therefore,
limited only to those.
in the repetition, not one sentence saying I have participated, submitted my application, I was before this court to do it, I did it under the order.
Lords, the answer to that is this. Lord, my learned friend has not seen the writ petition properly. 3 places, Lord, I have stated that I may be allowed to participate in the ongoing verification process.
No.
But-
That's a different thing.
Yes, my Lord, I am coming to that.
Yeah.
All 40 of them, my Lord, I have again checked. All 40 of them have applied, my Lord. Within 5 minutes, I can give all the application numbers. That's point number 1. Point number 2, my Lord, on this aspect of whether petitioner should be permitted or everyone should be permitted, all these 4 judgments of the Honorable Supreme Court that I have relied upon, Lord, I'll show the exact line. They have permitted only the petitioners. They have not permitted anyone else. All these 4 judgments, I can show that line within a minute.
No. You see, that's not the issue.
Yes, my Lord. There is
The issue is this.
my Lord.
If you have submitted your application
My Lord.
within the last date
My Lord.
of the advertisement,
All 40 of us have done it.
then if it is there, then you
All 40
consider.
of us have done it.
It
One
will be
second.
considered.
My Lord, that may not cover for one reason, my Lord, because the same very, my Lord, the state took an argument in the coordinate bench today, my Lord. One second. Sir, if you don't mind, I didn't oppose you. I didn't oppose me.
You have
Please let
opposed
me
me
complete.
every time
Please
I
let
tried
me
to speak
complete.
out.
Please
Sorry.
address the bench. There they took an argument today, my Lord, that what we have said before the division bench is this, that we will consider them for verification, but whether they are eligible to participate or not, that we will decide later. Now, the question that I put to myself is, what is coming in my way of eligibility? It is the 2nd January 24 notification. So I have absolutely no problem.
What 2nd January?
Malod, the notification which I just read, Malod, where
Page
this,
117.
I'm sorry, Malod.
117.
Yes, 117, Malod. So therefore, this needs to be stayed, Malod, because again, Malod, this has not been withdrawn till date.
No. That can also that also can be looked into. You see,
Malod,
without staying it,
I'm sorry.
otherwise it be amounting to maybe giving you the final relief
Malod,
at an interim stage.
mean final.
No, you see, what we can always do is we can always say that you should be considered, and the final result should not be published without the permission of the court.
For no one should be published. And there is a reason for that.
That's
Malod.
not,
For no one should be published.
correct.
I have absolutely no problem with that. For none of the
So it can be done. It can be
Yes,
decided.
What I would suggest is that technically similar petitions are
No, why should this? I'm sorry. I
on the
oppose
3rd
that.
of May those matters are
No, I'm
taken,
sorry.
if I'm not wrong.
He's argued the matter.
Then-
Now he's saying, Malord,
Just
it
a
will be
minute,
sent there.
just a minute. Yes.
Now, we are arguing those matters only on the validity of the 18 months d.el.ed vis-a-vis the 2 years d.el.ed. They are similarly situated is what I understand. What I understand, I may be wrong because also complicated. So, what I would suggest is, this matter gets tackled. Lordship orders that the orders which have been passed in the division bench would cover these matters also. Matter ends.
No, Malord, I'm sorry. That's an unfair statement to make, Malord. After having argued, Malord, when Malord expressed categorically that result for no one should be published because there are 5,500 people, Malord, and I can't be fighting pillar and post if third-party rights are created.
No. One thing.
So then this is coming. I'm sorry.
One thing is, you see, it's you are wasting your breath for nothing. The issue is this basically, is that according to you, in terms of the orders, subsequent orders passed, you are entitled to participate. You have the eligibility criteria. We'll allow you to. We'll allow that your verification documents should be done.
Verification.
The document verification should be done, and that at the time of consideration, you should also be considered. Now that will take some time. It will not finish in 1-2 months. I think it will take at least.
Malord, just see their notice. 7 days they are finishing the verification. 7 days. This is the notification for a minute. It is at page 71.
Huh?
The same very notice is at page.
Just a minute, Mr. Counselor. The second verification.
Verification notification will come out because the second verification notification we have to start after the orders by the division bench. So that notification is yet to the division bench is verified. Persons who have applied per the statement of the educator would be taken into, would be verified.
Why?
This is only
No,
a stage of
why this all this one division bench, one coordinate bench, one here? Why can't all these issues be taken up by the division bench together?
But there's
But
nothing
that
pending in the
division,
division.
that retail has been disposed of.
Oh, this
Letter B has
All
been
retail is
disposed of.
disposed of because they were all against interlocutory orders.
okay.
They are all disposed of. So now, if this matter fixed on that, let us not tag it together. Let us fix it on that. Let it be heard on that. 18 months, okay. 18 months, everybody is okay.
No, I'm sorry, Manoj, I oppose that for one
And
reason,
if
my
it is to
lord.
be argued differently, then perhaps
No, no.
we are thinking of presenting different arguments before different
That's
courts. What
very
I'm trying-
unfair of my learned friend. In fact, I had the opportunity to assist the coordinate bench also, my lord. There a stand was taken differently, my lord, saying that we are not deciding the eligibility. The division bench's order is only to consider them. Whether they are eligible or not, we'll decide later. Now, once my lord expressed that we will not let the results not be published for anyone, now they say that let it go there.
No,
So therefore, my lord, kindly
that
consider.
was just thinking out aloud. That's nothing.
Yes, my lord, it is about really, my lord. Today, where are we, my lord? There is a direct order of the Honorable Supreme Court clarifying.
Anyway, you see, nothing will happen by which date was that? 5th May.
Third, no, it's not.
Well, the next date? 6th May. 8th May.
8th
of
May, my
May.
lord.
8th of May. So we'll fix it on 8th of May. In the meantime, they should allow verification.
For
And
the orders of the division
huh?
bench. In accordance with the division bench order.
No, there is
No,
that
no.
division order.
If they have applied,
Once
yes, if they have applied, that I will clarify.
division benches
As
order.
per, I will clarify that.
No.
If they have applied in any of the advertisements prior to the last date,
Yeah.
and if that is the criteria, if the criteria is 24, since they have 18 and they come within the conditions laid down, that is that by 2017 they should have been in
Yes.
service, and they have
They have
completed
diploma.
the
Yes.
thing by 2019, then they should be considered.
Yeah.
And verification should be done.
but
Yes,
that
but-
order is already there in the earlier division bench order.
Now, I
That
was not a
will
party,
always-
my lords. What is the difference?
then you
Difficulty
let
in
me-
reiterating.
if you let
I was not a
complete,
party.
you
I don't
understand
understand what is the
Okay,
apprehension.
okay. I think
It was
I've heard you both.
30 more
I think I've heard you
I
both.
just need 30 more seconds if my lord. to
Huh?
speak.
No. You all have taken 1 hour.
I understand. I'm sorry for that.
No.
Let's just give me 30 seconds.
You're lucky that I completed my board fast.
Look,
And I thought I will do my CAV matters.
I
I
apologize, my lords, that we.
I had to leave this thing is 9:15. 9:15 I left the chamber last night.
I sincerely apologize, my lord, for any.
Huh? Yeah, I've got another matter which
We are not the only
mentioned
culprit.
this morning only.
We are not the only culprit, my lord. But just 10 more.
So you see, the thing is that I've heard you. There's
Well,
nothing
only-
more you
only
can
for
add.
my
right now.
satisfaction, my lord.
Not, I don't want your satisfaction. I want my satisfaction.
I understand. My lord, just
Right.
give me 10 seconds.
Heard, mister?
Well,
What is
Mandeep,
it? Huh?
Mandeep Kalra. My lords, I'm not speaking on the brief, my lords. I'm not speaking on the brief. I'm
Yes.
simply speaking something, my lord.
What?
Because I had the opportunity to assist the Honorable Supreme Court in this matter, my lord. My lords, my record that the effective, and not for this case, I'm saying all 40 have applied. My statement may be recorded, no problem. I've verified. But there may be more petitions that may come in, my lords. I'm saying that responsibility. The Honorable Supreme Court made the review applicable from the date of judgment, which is 28/11/23. The advertisement is of December 23. The
No.
advertisement.
Whatever it is, those who have missed the bus have missed
Yes,
the
my lord.
bus.
I'm just, as I said, I'm not arguing.
No.
on the brief.
Enough.
So therefore,
enough.
that may also come in.
Enough. Heard, mister?
Mandeep Kalra
Mandeep Kalra. You're from where?
from Delhi.
From Delhi. Oh. Good guessing. Learned counsel for the petitioner who submits that the petitioner had completed their 18-month d.el.ed diploma obtained via NIOS (ODL mode) for recruitment and promotion purposes. He submits that though the Supreme Court in the case of Jaivir Singh, Jaivir Singh and others, was state of Uttarakhand and others, reported in 2023, STC Online SC 1584. That held in para. And
The clarification orders
no, that's the clarification, the initial order.
the initial order, my lord, would be para.
However, while subsequent orders passed by the Supreme Court and especially the earlier judgment of the Supreme Court in Jaivir Singh Supra and the case and the case and the case of Vishwanath, what is that?
Vishwanath versus State of Uttarakhand.
Vishwanath versus State of Uttarakhand. Citation?
Citation will be die number 4961 of 2024.
4961
Yes,
of
2024.
that is civil appeal.
No, it will be die number only.
Huh?
Review petition die number.
Review petition.
Die number. RP diary number.
Where is that page?
That will be in at page, my lord.
By way of the 18 months program through NIOS prior to 1/4/2019 was a valid diploma holder and at par with any other teacher who had completed the 2 years d.el.ed program. Yes, sir. The petitioner's counsel submit that as the judgment of the Supreme Court in Kaushik Das Supra has practically reviewed the decision of the Supreme Court, earlier decision of the Supreme Court in Jaivir Singh Supra, the impugned notice dated
Second that.
2/1/24 issued by the Director Elementary Education, Assam, wherein it has held that, wherein it has been stated that the qualification of the 18 months diploma in elementary in DL D full stop EL full stop ED acquired from NIOS was no longer a valid qualification to be eligible for fresh recruitment to the post of teachers should be set aside. Next paragraph. The petitioner's counsel submit that as the petitioners have submitted their application for participating in the selection process for recruitment of teachers in LP and UP schools pursuant to the advertisement -A and advertisement -B mentioned in the notice dated 2/1/2024. The respondents who have started the document verification process should also verify the documents of the petitioners here. That's your case?
And no, this needs to be stayed.
Huh?
This needs to be stayed. Because even if they verify.
No, I'm not staying. No.
Look,
the stay will come later.
Look,
If you have the case, then the entire what stay? The entire notice will
I'm
go.
not saying that appoint me for now. I am saying that at least consider me in the merit list.
No,
That is what my case
that too will give you. That too will give you.
Lords, because this is an argument that was taken today by the same very state.
Anyway, we'll see. We'll see. Not on the first day. Some of the
Look,
first.
my kindly, people are bear with me from.
Just
I'm not asking for a stay.
Mr. Counsel, I've heard you. Please.
That's my case.
Yeah. You have to rest your case. Otherwise, I'll rest my voice also. All right. Mr. R. Mazumdar, or who? R. Mazumdar. Learned counsel for the for the
Department of School Education.
Department of School Education. Yeah, additional? No. I think that is for big Ogoi and thing only, no?
Yes, they are.
Uh, the, for the Department of School Education. Submit that the issue that has been raised here had also been considered by a division bench of this court in WA 104 of 2025, and that by an order dated 2/4/2025, the division bench had recorded the concession given by the learned advocate general of applications in pursuant to any advertisement. Their documents would also be subject to document verification. That's all. Next paragraph. On considering the submissions made by the counsel for the parties, this court is of the view that if the petitioners have submitted their applications for participating in a selection process for appointment of teachers pursuant to the advertisement A and advertisement B, which are mentioned in the notice dated 2/1/2024 issued by the Director of Elementary Education, the state respondents should allow the petitioners hearing to participate in the document verification. Full stop. Further, in the event the selection process proceeds beyond the document verification stage, the petitioner cases should also be considered if they pass the document verification.
The earlier repeated judgment says the results are not to be declared.
Yeah, that's right. However, the results of the petitioner should not be published without the leave. Full stop. Next para. As it has been submitted by the parties that an analogous matter, that is WPC number
477 of 2024.
477 of 4 of
477
477
2024
2024 is going to be listed on 8/5/2025. List the matter on 8/5 along with WPC service. Along with
So that is a part heard back. So, my lord,
the same thing.
Yes.
That will cover this.
Correct.
The issue will be the same.
Correct.
If he has heard that, that means he has heard half of this.
obliged.
I'm so deeply grateful for a patient hearing.